Admiralty law goes back, way back, goes back to the time of the Phoenicians. And when you're talking about limitation of liability, which is the big issue that came up with the Titanic, and that really can be traced back to the 1700s. It was a law that was set up to encourage commercial shipping and to protect an individual owner. Well, now we have corporations, yet the law still exists. Now we have insurance, but the law still exists. And in the Titanic, the end of the story was that they were able to insulate, the owners were able to insulate themselves from liability, from the people who were injured, from the cargo interests who were people who owned cargo, lost their cargo, and from people whose family were left behind after their loved ones died. The total amount was about $95,000 paid out to all of the lost payees. It was a terrible tragedy, but it came under limitation of liability, which is what a ship can do to in the United States to make sure that that you pay out very little. But it's carried to such a ridiculous extent now that a wave runner owner can limit his liability to the value of the vessel at the time of injury, at the time of disaster. So just think about it. If the ship sinks, what's its value at the bottom of the sea? Well, maybe some of the cargo that floats up to the surface. That's what you can do with limitation of liability if you're an owner. It's this old saying, and it's the captain went down with a ship, but the owner escaped with his life and wealth intact. And therein lies the problem with the Limitation of Liability Act. It does more than it was intended to do. It's outlived its useful life, but we have to deal with it. And you need an Admiralty attorney who understands its rules to make sure that you're able to obtain justice when the owner of a wave runner decides that he wants to invoke the Limitation of Liability Act and limit the amount for which he is liable to the value of the vessel, which isn't very much.